So this is him. Oral argument of cost of incarceration before the Florida's 5th District Court of Appeals. So let's play a few minutes so you get a hang of how, who he is, what level he works at, and hopefully that will give you some knowledge on what we're dealing with here.
And for the record, this is the second case on our oral argument calendar, Seth Connor Wells versus State of Florida. Is the appellant prepared to move forward?
We are, Your Honor.
Please proceed. Before you do, how much time would you like for rebuttal?
Well, in deference to my honorable colleague, I'd like to split it half and half because I know he's going to put the fire on me, so I'd like to have enough reserved time for rebuttal.
Okay, so that would be 10 minutes?
If I get 20, that'd be 10. Thank you, Your Honor.
Thank you. Please proceed.
Yes, Steve Gosney representing Mr. Wells. And this case is Mr. Wells was put in prison for a series of felonies. He was then had a tail end of probation. And then one of the conditions of probation was that he not dress up for Halloween in a costume that appeals to children. And then also another provision was he had a 10 p.m. curfew. He was found to be violated for those two violations. And for that, he received 22 years in prison, as well as a $400,000 cost of incarceration. I'd prefer to focus on point 3, which is the constitutionality of the cost of incarceration for the purpose of this oral argument. The cost of incarceration it has not been tested in Florida constitutionally.
Before you get there, counsel, and we can certainly get to that in a minute, but as to the point about the violation of probation, did I hear you say, because I don't necessarily see this in the order of probation, that there was a prohibition on him dressing up at Halloween? That's not the way I read that provision of the order, but maybe I'm mistaken. So
no, actually, you're absolutely correct. And one of the questions here is, do we read this order carefully as lawyers and strictly as a probationary order, or do we read it sort of loosely and say, well, it's just a Halloween costume and whatever it is? I would expect this court and law generally to be very strict with the reading of the probationary order. And if you read that, it lists a number of costumes that are not allowed. For example, Santa Claus, Easter, and then in the Halloween context, it's basically all of these things. The one, in order for him to be violated, has to show that it appeals to children. And then there is also an additional modification. If you read it carefully, it says, and passing out candy and Halloween type activities.
Well, and I'm looking at 44B. This is
all right. Let's bring him on, and he might explain what this case is, and then move on to the young thug trial and his opinion of the development this week. Everybody, I want to introduce you to a phenomenal lawyer. He is death penalty certified appellate attorney, and he is my friend, Mr. Gosney. Welcome to the show.
Good to see you, man. I'm back, baby. Yeah, well, thank you for inviting me on. This is my first I did have a little hello back to Joe stream, but he had a big panel and it was basically a thing. But you're my first, this is going to be like me commentating on stuff, and I really appreciate the invite. We'll see how long I can go, because one of the reasons I've been streaming is because I've been learning a new practice of law, which is civil, and I'm just worn out, and so I don't have the energy to give my best. And when I'm on, I want to give my best. So you were asking about this particular case. Well, this is a fascinating case. Yeah. So my client, Mr. Wells, was on probation, and he was not supposed to dress up in costumes that appealed to children. Okay. He was working, and his curfew was till 10 p.m. at night. Now, he was working at Denny's on Halloween, and he dressed up as a devil to get extra tips at Denny's. and worked late to 10:30 at night. Now the question so he had 2 probation violations, one of which was dressing up in a costume that appeals to children. Well, the devil costume, there was no photograph and there was no testimony that the costume appealed to children. It was just a devil costume that he had made, and there was no testimony in the record. So he did not violate that order of probation. Now he was 30 minutes late because in his curfew. So because he said, if you leave here, then you will be fired. And so he had to choose between staying and cleaning up. He was the last employee, or getting fired. And if he got fired, then he's in violation of probation too. So he stayed a half hour late on his work. He's working, which is great for a felon, right? And it's hard for a felon to find a good job. So for those 2 violations, the court in Citrus County, Florida, sentenced Mr. Wells to 22 years in prison and gave him a $400,000 cost of incarceration. So now on this oral argument, I was challenging both the violations and the cost of incarceration. Okay. Now you will know that I won on the costume issue. So the court came down and said he did not violate on the costume issue. So that was right. But he did violate on the curfew issue. Therefore, the 22-year in prison, $500,000 or $400,000 cost of incarceration stood. Well, because of that, and this has been a big issue in Florida for me, one of my pet projects has been to challenge this cost of incarceration because it's basically so burdensome. And if you calculate it out, and it's in the brief, if you calculate it out, this guy here, Mr. Wells, when he gets out of prison, that $400,000 fine will exceed his lifetime expected earnings. So I'm arguing in the brief and to the court here and to the United States Supreme Court, for which this issue is pending, I'm arguing that $400,000 cost of incarceration is violative of the constitutional prohibition against excessive fines. And if it is a fine, and it is excessive, because for a fine that exceeds your lifetime expected earnings is excessive to me. And then the question is, and so the question before the United States Supreme Court is whether or not the excessive fines clause of the U.S. Constitution applies to costs of incarceration schedules. And that has United statewide impact because there's all these costs of incarceration. So you've just got it more. Boy, you got the thing. So this is pending. They have not accepted cert, but they have ordered the state to respond. The state did respond, and then I responded, and it's passed around for conference. So it is pending before the United States Supreme Court.
Mm-hmm. So we might, once they decide, hear you in the United States Supreme Court.
Well, I'm not with the public defender's office anymore. So probably not. You know, I don't know but what happens if cert gets granted by the U.S. Supreme Court? I actually was working with a nonprofit up in D.C. that is interested in this case because so that I would expect that if it goes to the U.S. Supreme Court that they'll take over the case. And I have no ego involved in any of my cases. I mean, I'm in it for the clients and for the people of Florida, and I want to see justice done. It's just unjust that we destroy people's lives. We basically make it impossible for people who go to prison to ever lead any kind of productive life. And, you know, that's anti-American as far as I'm concerned.
Okay, that was a great introduction. And I hope that it succeeds because I am of the same opinion. Now we do over here, over this side of the pond, we don't have that at all. The people have to pay to be in prison. So we don't have that, but we still have the usual stigma of former prisoners trying to get work, and which is sometimes in violation of their probation, which some employers use and say, you have to work, here's $2 an hour and don't complain because then you're fired and back in prison. And so that's an issue over here as well.
Yeah, and it's real tough because his probation violation was he was working too hard. He violated his curfew. He worked a half hour late. The probation office basically wanted to give him a more strict form of probation, but the judge over in Citrus County gave him 22 years in prison. It's insane, very vindictive, and these are people with lives, and it's just a shame. Can I make a couple little shout outs? First of all, Excited Utterance is here. I want to say hi to Slidey Pie, and I want to send out my best wishes of all to Fiery Red Podcast, who is still fighting cancer and who is kind of one of the things. He's like a beacon of hope, along with a lot of my internet friends who have been praying for me and been very kind and sent their good wishes. And it's helped me quite a bit because I was very low and I've been working hard to get out of that hole. And so I want to thank everybody, but especially those people, and say hi to Fiery Casper. I see all you chatters, don't worry. But it's hard to say hi to everybody, but I wanted to point out those people especially.
Yeah. All right. Now in for the subject matter at hand, the Young Thug RICO trial. And we had some interesting development this week. And Mr. Gosney has basically no idea what it's about, but I wanted his fresh opinion because there's so many of us.
I'll say that I know, first of all, I watched it when this was like many moons ago.
Yeah.
Back when it kind of, there was something that happened and it hit the news and everybody covered something. But the thing is that this should have been a mistrial ages ago. Why this trial keeps going, I have no idea. Now, I haven't followed it since then. I've been kind of off the radar. So I'm sure there's a lot of good stuff that I'm not aware of. So I kind of have a familiarity. The prosecutor is out of control. She's got too many defendants. She's charged it too broadly, and it should have been mistrial long ago. That's what I know.
Yeah. Okay. But let's start with this all the way back to day 69, no pun intended. And this is cross-examination of Detective or Sergeant former Gaither, who has Mr. Shard and about some missing reports. So let's listen here.
Road to retrieve surveillance.
I did.
Was that in relation to the investigation of the January 10th, 2015 murder case?
Correct.
Okay. Surely, as you were working a murder case, you would have written a report about your efforts to obtain this surveillance, correct?
Not necessarily, no.
So did you write a report or did you not write a report about going to the McDonald's on Old Hateville and Cleveland Avenue in search of surveillance?
There was nothing to write, sir.
So you did not write a report?
There was nothing to write, sir.
Okay, so now I'm going to ask you a question. I'm going to ask you for an answer. Did you write a report?
Your Honor, I object. Ask him the answer.
I sustain the
I haven't
objection.
received an answer, Your
I
Honor.
sustain the objection.
Okay. What day did you go to the McDonald's to obtain this surveillance?
It's the day after I spoke with a witness that gave me the information. I believe that day was January the 26th, I believe. The 26th or the 28th, somewhere in that range.
Okay. 26th to 28th. And do you or anyone else that you know of have a report reflecting that you went on the 26th or 28th?
Objection. Ask and answer.
Sustained.
Okay. Who did you speak to at the McDonald's? What was their name?
The young lady that was working the counter,
Yes.
she did not give me her name. She gave me her general manager's name and phone number, and that information was passed along to Investigator Thorpe.
And what was the name?
I don't have it. I gave it to Investigator Thorpe. Sir.
What was the phone number?
I don't have any information from the McDonald's. It was passed along to Investigator Thorpe.
I have no further questions. Thank you.
All right, sir.
Now, the lack of reports have been continuous with Detective Gaither. This is an example of it, that she even though she received information, passed it on, she didn't write an individual report about this specific event, about trying to obtain surveillance footage from the local McDonald's. On top of this, she left the Atlanta Police Department in 2020, after 19 years. For some odd reason, she didn't go the full 20 for full pension. And she put all her reports, everything she's done, everything in a file cabinet. And the argument from the prosecution on day 69 was that these reports, they can't find them, and the digital copies were lost in a 2018 hack event, which affected the entirety of Fulton County Public Prosecution's Office. So since day 69 and before that, basically no reports. Now let's go up to day 140.
I'm starting to anticipate something. I'm starting to feel like I kind of get what's going to happen here, but let's see it unfold before our eyes.
Yeah, and this is day 140. Nobody has told. Well, let's just watch what happened here.
Let's watch and enjoy and let it sink in.
Not off the top of my head, no.
Would seeing, first of all, did you keep a file for that case?
The kidnapping case?
Not the
What?
kidnapping case, but for the Browns Mill Road shooting case.
I did.
And did you have that file after you left the Atlanta Police Department?
No.
What did you do with that file?
I left it with the Atlanta Police Department in a file cabinet.
In a file cabinet?
Yes, ma'am.
Describe what that file looked like, if you can, to the jury.
It's approximately 7, 8 inches thick. It was reddish brown file folder binder. Had clips in it, a bunch of paperwork.
Did you look at with the state any such file before coming here right now?
Did I look at it? Yes.
Okay. And did you recognize that to be the file that
Yes.
you kept? Okay. Which showing you.
Wait a second now. All right, so I got a lot of questions here.
Mhm.
I will say that the asked and answered objections from the prosecutor, to me, were cover-up objections. I'll bet you they knew that such a thing existed, and they wanted to cut it off so that they'd have maximum wiggle room, so that when they produce it at a later date, then they would be able to say, oh, but they didn't ask the specific question, right? So to me, the early objections were disingenuous. Why would you object to that specific question? Asked and answered. She says she didn't have anything. It's not objectionable. The question wouldn't hurt anything. It just delays the proceeding. He's trying to nail her down, and they're protecting the witness from answering. Now they're late disclosing. To me, those objections mean they knew about it on day 69. That would be my first that's intuition, and I've got an intuition, and I can't prove it, and I can't say, but this is just commentator shooting from the hip intuition. I would say that the prosecutor knew that report existed on day 69. What say you, Nick?
Let's continue playing.
Okay.
But first of all, remember, she asked, did you see this file before we walked in? And she said, yes. Is this the file that
And then
you
the next
left
question is,
yeah.
when was this disclosed to the defense? When was it discovered? Because somewhere, I'll say, let's assume that they weren't operating in bad faith in day 69.
Yeah.
When did they discover the file? When did the witness then say, oh, I have this file back in the file cabinet, and then they point to it, and when was it disclosed to the defense? These are basically, in Florida, we call it Richardson violations, which is, but let's see how it unfolds here.
Yeah, but I want you to just remember how she asked the question here was, did I show you a file? She answered yes. Is this the file that you had back then? And she says yes. That becomes important later.
A portion of that file, refresh your memory as to what phone number that you had.
Your Honor, may we approach?
Yeah, that's right. Yeah, we have some issues.
Your
here,
Your
yeah,
Honor, may we approach? These lawyers are excellent. They, within just a few questions, because Prosecutor Love has had quite a history of trying to sneak. Now, there's a standing order from this judge that every piece of evidence attached to every witness must be disclosed to the defense before the witness takes the stand. The Friday before, if it's the next week at the latest. And now they're asked to approach.
But orders are toothless if the judge doesn't enforce them. This should have been a mistrial a long time ago. It should be a mistrial on this issue alone. And every time I encounter this trial, I see bad prosecution after bad prosecution. I see mistrial after mistrial. And I don't know. I just think that, and every one of them, if I was a judge, I would have granted every one of them. So why this thing keeps continuing and wasting all these defense lawyers' times and all these jurors' time and everybody's time, I don't know. I don't understand why the judge doesn't have the, cojones to go ahead and just grant the mistrial.
Yeah. Do you know how, just for shits and giggles, guess how many motions for mistrial there has been in this trial so far?
Boy, that's a tough question. Well, I remember one day on a trial I had, it was a one-day jury trial. I had 4 mistrial motions in one day. But I don't know. That was crazy. I don't know, maybe 20 or 30. Let's go 30.
45.
45.
Which is the most in US history in one trial, apparently. 45 motions of mistrial. Now, they took a break. She is sending off the jury for an early lunch, the judge.
But now I see this a new judge. The last I saw this last I saw this case, the other judge was on there. So he finally recused himself, which he should have done.
No, he was recused. He didn't recuse himself.
Good. Well, that should. But it's over. I mean, this case is, it's horrible.
Yeah.
This is just not justice.
Let's listen to what happens.
Embarrassing.
An early and long lunch.
All right, we'll do.
Before we ask Investigator Gaither any questions, I would ask the court to inquire of the state when they received this file and how they received this file, because we're completely in the blind.
Okay.
We went over to the Atlanta Police Department,
When?
obviously before.
Is your mic on?
I'm using a mosquito mic, but yeah.
Just before we served, I think we called it complete case files from Operation Planners incident. This is where we got this one,
A bit spoiler. They have had the file for all the time, but it was not attributed to Gaither. So it was in discovery back in 2022 amongst a plethora of different files but this one wasn't named.
Was it provided to this? Was it provided to the defense?
It was in this. Yeah, they handed it over amongst 7 terabytes of other documents, so it was buried in discovery. And now they claim,
Okay, so
oh, we didn't realize it was Gaither's.
I'm just trying to get it clear here.
Yeah. So it was in
Well,
discovery.
now I want to see the document, because does the document have Gaither's say? But she answered on the stand that she wrote no report.
Yeah.
So she's committed perjury in front of the court. Ugh,
Yeah.
Sick. Yeah, I mean, and the thing
other
is
ones that were included in that discovery tranche from the Atlanta Police Department. That's where they came from. The one titled Complete Case Files of 2015 Operation Planners. If the court will allow me, I will ask our legal assistants to give me the date that we served the file called Complete Case Files of Operation Planners.
Okay, and so the contents of that file were served whenever that was?
Yes.
All right, what led you to suddenly ask Detective Gaither if this was her file?
As I was looking through for a particular number, I was trying to find both that photograph where Mr. Zachary had signed A515 NARD on the Browns Mill Road photograph. So I was looking for that. And I was just looking through everything that we had. And in looking through it, because I knew I'd seen it somewhere, I found it in this particular file folder. And looking at it, I initially I'll show the court what I was about to show.
Well, why don't you put it back together? And I know we're asking you to do several things at once. So how about put it back together and then you can finish your answer.
Hold this. Planners complete case file. That's what this is.
And now they remember, and they are talking into the microphone. Now, this is interesting. Let's skip ahead, because I want to show you.
Finish your answer as to why this suddenly.
Yeah. Now, through Gaither's recollection, oh, it was a red brownish. Well, if she saw it before she walked on the stand, yeah, of course she would testify to that. Then there is some development. This file, which she on the stand said, yes, this is her file, actually says it's signed by her, but it also says copy. That is sent to the district attorney's office, that district attorney back in 2016 something used as material. So it's not her file. It is parts of her file combined with notes from somebody else and other information that it's not from Detective Gaither. So when she identified that as her file, you're completely correct, Steve.
See, here's part of the problem with what's going on here. You know, it's like, you know, there's a famous Clint Eastwood line that a man's got to know his limitations, right? Clearly, this prosecutor's office is not capable of conducting an organized trial this large and this complex. They should recognize, they should have enough self-awareness to say, we are not competent here. We are limited. We have limited resources, limited abilities. I'll tell you what we need to do is break this into smaller component parts and do little trials rather than one justice to solve them, one trial to solve it all. Break it into smaller parts. Yeah. Keep your trial lean and mean. Try one case at a time. This clearly is way over their heads ability to do. They're not organized. They're not under control. They don't know what's going on. So to me, this is all error on the prosecution by shooting over their pay grade. They don't have the competent people to do what they're supposed to be doing here.
Yeah. And for
Starting
instance,
with the top.
Yeah, and as you heard Prosecutor Love say, she was searching for a certain type of information. Well, the prosecution said they were ready for trial in December of 2022. How is it that the weekend before or week before, she's still searching for stuff to ask a witness they have had planned for over a year?
Well, and if it was one error in a long trial, and this is the first time this gone up, it would be excusable, right? It would be okay, we made a mistake here. Everybody makes mistakes. But when it's how many mistrial motions? I mean, it is baked in the cake that this prosecutor is unorganized, over their head, acting in bad faith, presenting perjured testimony, playing games that are contrary to justice, and it should have been thrown out a long time ago. I remember last time I was on, which I don't know what day that was, but the other judge was still on, and I think it was the contempt motion against I think that's what it was that it was like that one witness that was mistrial all day.
Yeah.
But I don't know. I mean, I don't know what's going on in Atlanta or Georgia generally, but people in Atlanta should be ashamed of their DA's office.
Yeah. Some time ago, I believe it was Doug Weinstein, who had a motion for quick prosecution, more or less asking the judge to put a time limit. Now, a judge can't tell the prosecution how to run their case, but they do have the authority to put time limits. And the DA's office were so offended by this. It was.
They should look in the mirror. I mean, who do they think they are? These are representatives of the people. Their job is to uphold the law. It's not a glory ego trip on parading around and showing in front of the cameras what a brilliant attorney you are by talking everybody's ears off and boring the jury and trampling the rights of defendants.
Okay,
that's not the job of the prosecution. The prosecution is supposed to uphold the law.
Yeah, but when it comes to Prosecutor Love, I've covered another case involving Prosecutor Love, the Shane Kendall case, and where she lied to. It was a hearing about competency. Shane Kendall, severe mental illnesses and issues. And she lied and managed to convince. I don't know how Georgia can have that. It was a jury who decided competency.
The first prosecutor lie, there was an obvious lie. I'd been to a mistrial. As soon as you tolerate number one, number two is much easier to say, oh, well, we already gave a pass on this one. And now what lie we're on? Probably lie 45, right? I mean, there can be no tolerance for the state's lying on a criminal. This is a citizen whose liberty is at risk. This is somebody who is a citizen of the United States, who the state is seeking to put in a cage for the rest of their life, right? And we're going to allow the state to lie? No. That is not allowed. That is not what is. But as soon as you we're going to let that little lie pass. It's okay because you're powerful or you're somebody who's important or you're a prosecutor or you've got some title or badge. We are drowning in lies in this country. And sadly, the prosecutors are leading the charge right here in Atlanta.